Good morning, everybody. My name is Dale Page. I'm the presiding member of today's Metro Inner Development Assessment Panel meeting. I welcome everyone in attendance, both in person and to those online. I declare the meeting open at exactly 9:30 a.m. and acknowledge we're hosting this meeting on the traditional land of the Whadjuk people of the Noongar Nation. We acknowledge the Aboriginal people as the traditional custodians of Western Australia and pay respect to elders past and present and the ongoing connection between people, land, waters and community. This meeting will be run in accordance with the DAP Standing Orders 2024 under the DAP Regulations 2011. The meeting is being recorded and live streamed on the DAP website in accordance with Regulation 42A of the DAP regulations. Members are reminded to announce their name and title prior to speaking. Panel members may also refer to technical devices throughout the meeting to assist them in considering the information before them. Item 2, apologies. We have apologies from Councillor Russell Jones from the City of Subiaco, Councillor Rick Powell from the City of Subiaco, and Councillor Phil Marks from the City of Belmont. Item 3, members on leave of absence, we have nil. And item 4, noting of minutes. Minutes of previous meetings are all available on the DAP website for review. Moving now to part B, which deals with the City of Subiaco items. I'd like to introduce the panel. In addition to myself, we have Francesca Lafonte to my left, Eugene Coltaz also to my left, Councillor Penny O'Connor and Councillor Simon White. We also have some members of the City of Subiaco staff in attendance to respond to any questions. And we have applicants and submitters present with us, Ken Perry, Philip Dobson and Daniel Hollingworth. Declaration of due consideration. Could I please confirm by a show of hands that all panel members have duly considered all the documentation contained within Part B of the agenda and Part B related information? Thank you. Disclosures of interest. We have disclosures of interest that have been received from Councillor O'Connor and Councillor White. Councillor Connor disclosed that she had participated in a prior council decision on the matter, and Councillor White participated in a prior councillor decision and sat on the original panel that decided on the development at item 4.1. The interests declared by Councillors O'Connor and White align with the standing declaration of interest for local government DAP members. That is, if the agenda items have been considered at a council meeting, the local government DAP members acknowledge, as per section 212 of the DAP's Code of Conduct 2024, that they are not bound by any previous decisions or resolution of the local government, and they need to exercise independent judgment in relation to the matters before them. Given their dual role as councillors, I have agreed that they are able to participate in this meeting. I have also declared an impartiality interest in the item, given I was a previous board member of Development WA. However, I haven't been a board member for well over a year, and my previous involvement as a board member should not impact my ability to consider this application in an unbiased, impartial manner. The Deputy Presiding Member has considered the declaration of interest and agreed that I'm able to participate in the meeting. Are there any other interests that any member would like to declare? If there are none, we'll proceed now to items 3 and 4 on the agenda. Item 3, Form 1 DAP applications, we have nil to consider today. Item 4, Form 2 DAP applications, we have item 4.1, relates to lot 30, number 20 to 22 to 24, Hood Street, Subiaco, deletion of condition 11 and associated amendments to the development plans, DAP number 23-02484. We have had 3 requests for presentations on this item. I need to remind presenters that in accordance with clause 482 of the DAP standing orders, your presentations are limited to 3 minutes. I'll give you a heads up when you're nearing the end of your allocated time, and then panel members will be able to ask questions of the presenters after each presentation. Mr. Ken Perry, would you like to step up to make your presentation?
Thank you very much, Madam Presiding Member. Good to see some familiar faces who are still around the table. One of the reasons I keep making submissions and appearing on quite a wide range of development applications, both at the WAPC and the various DAP meetings, is because I believe there's just so much wrong with the way the planning system is being administered. I have documented the many errors as I've found them, and some of which have now been corrected. I've pointed out the lack of basic principles underlying the system that must be followed if the planning system is to regain its integrity. And I've pointed out the dangers of allegations of conflicts of interest and corrupt practices from undue developer relations and political interference. It's sad to report that there now appears to be a general political groundswell that the system is broken and must be fixed. Therefore, you as decision makers, and I'm referring particularly here to the 3 government appointed decision makers, are in the spotlight. And I think you should recognise that you're exposed for criticisms on the decisions that you make. So what about today? It's simple. WeLink bought the property knowing that affordable housing was required. WeLink accepted this as a condition back in August 2023, and they did not appeal the decision at that time. Instead, WeLink have applied to have the affordable housing conditions now removed because they've got an economic problem. One of the guiding principles for our planning system is that economics are the industry's problem to deal with, not the planners. Regulators are just that. You regulate. You're not here to provide incentives. Once you start thinking about that, you have to worry about whether you're the gamekeeper or the poacher in all of this. And this is why there's so much widespread criticism out there and a growing movement that recognises that. This application must be refused. The council has recommended refusal, and we need to take great heed of what councils say. And the RAR has recommended refusal. And you must give credibility to the city's planners. You must accept their recommendations. Thank you very much.
Thank you, Mr. Perry. Do any panel members have any questions of Mr. Perry? No? No. Thank you, Mr. Perry. Philip Dobson from Hodgkin Hanley.
Thank you, panel members. I intend to address you today on 2 particular aspects. You'll have seen some correspondence that I have written, and you will also have seen some correspondence from the law firm McLeod's, which provides a response to my initial letter. I want to address you today on 2 aspects. The first is what's known as the planning nexus. I'm addressing you on the lawfulness of Condition 11. Planning nexus between the development and the condition that has been imposed. And I'm also going to address you on the certainty of, or the lack of certainty of, the condition that's been imposed. So firstly, starting with nexus. It's well established that in order for a condition of planning approval to be valid, there must be 1, a proper planning purpose for the condition. 2, there must be a nexus between the development and the condition that's being imposed, and it must not be, thirdly, it must not be unreasonable. It must not be legally unreasonable. Now, I don't cavil with the notion that there is a planning purpose behind Condition 11, but in my view, there is not a sufficient connection or nexus between the development and Condition 11 of the approved development. You will have seen my second letter that I've sent specifically for today attaches a chapter or an extract from a chapter from the learned author of Planning Environment Law in Western Australia I would commend those comments and that discussion to the panel members. Say further that the predominant case that deals with this particular question in Western Australia is the decision of the Court of Appeal of the Supreme Court of Western Australia in Reid and the West Australian Planning Commission. In that case, the appellants applied to subdivide land into 2 lots, and the Commission granted approval subject to 5 conditions which were directed towards environmental outcomes. Both the tribunal and a single judge of the Supreme Court refused the Reid's application for a review of those conditions. And the reasons for doing so were because that the tribunal and the Supreme Court, that's a single judge, found that there was a connection or a nexus established because the development fell within a particular planning framework that required environmental considerations and sought environmental outcomes. That is the argument that you will see in the letter from McLeod's about nexus. In effect, because there's a planning framework that seeks a societal outcome, and this development
You're
isn't...
at your 3 minutes, Mr.
Oh my goodness, okay, thank you.
I'll
I'll
ask
be very
you
quick.
to wrap up.
Yes, I will, thank you. What I can say is that the Court of Appeal rejected that argument. It said that does not establish a nexus. A nexus must be established between the application applied for and approved and the outcome of that. It's conceded by McLeod's in their letter that there is no nexus between the need for social housing and the application that has been made and approved.
I'm going to have to bring you to a close.
Can I say one more sentence?
One more sentence. We have read all your documentation.
Okay,
so.
thank you. In my view, it is simply unarguable that this condition as imposed is sufficiently certain. It requires actions of third parties. That's 2 sentences, so I'll stop there. If you've read my submissions,
Thank you, Mr. Dobson. We have read your submissions and all the panel members have declared as such. I might ask, do any panel members have questions of Mr. Dobson?
No, it's junction.
I have a question, couple actually,
Yes.
Mr. Dobson. Do you believe your client was aware of development of the Affordable Housing Policy DP9 and the implications of said policy when they applied for approval and when they made a deputation at the DAP meeting last year?
I think that's apparent from the materials before the panel. Yeah, I wasn't there, but from what I can see, that there was an awareness of the policy, correct?
Okay. Given you weren't there, this may not be easy for you to comment on, but are you able to comment on why your client did not challenge or seek a review of the condition imposed on either the 2017 DA or particularly the approval granted late last year?
That may be a question better directed to the next speaker.
I will do so.
I simply engaged to provide advice on the lawfulness of the condition, not on the previous application.
Oh, good. Thank you, Mr. Dobson. Mr. Hollingworth.
Good morning, panel members. My name is Daniel Hollingworth with Lateral Planning. We're the applicant for the application of item 4.1, and I'm joined by Adrian Dew also from our office, who can assist in answering questions when the time arises. You've already heard from Mr. Dobson on why condition 11 is unlawful. The condition requires a particular category of a third party, which is entirely unrelated to our client, unknown to us, to enter into an agreement to purchase 6 dwellings at a rate that's set by a different third party. The conditions of sale to that third party are unknown to our client. They're not controlled by our client. We say they don't relate to the approval granted. and imposes a significant financial penalty to our client. Equally, you've seen a submission from Mr. Slark. Respectfully, we don't agree with Mr. Slark for several reasons. However, for the purpose of today, fundamentally that isn't relevant. The application proposes to delete condition 11. The circumstances which led to the submission of the application are comprehensively captured in our deputation request, so I won't cover the same ground, other than to say we don't understand the resistance to the outcome. And fundamentally, that's what we're here for, it's an outcome. It's not an application of policy, it's not a slavish application of policy, and it's not about definitions, it's about people who need housing. Ultimately, today, your determination comes down to what you consider to be reasonable. We attempted already to clear condition 11, and that was through the delivery of subsidised key worker dwellings. And that approach is consistent with the content of the development application that we lodged. It's consistent with the continued commitment of our client, and it achieves an outcome for the key workers in the same way as if they were sold to a third party. Our engagement with the city on the delivery of the subsidised key worker dwellings appears to be frustrated by a definition. There doesn't seem to be any disagreement that the outcome is a quality outcome and that the solution is consistent with the objectives of the policy. Fundamentally, the issue comes down to a definition contained within a policy, and we say that that is a slavish application of the policy. And fundamentally, planning is about outcomes, and our client is committed to an outcome that will see subsidised housing provided to key workers. I've been cross-examined by the city's lawyer, Mr. Slark, on several occasions, and I've done it enough to know that the objectives of policies are a relevant consideration and are to be given significant weight in the decision-making process. It's clear that our alternative approach to the delivery of subsidised key worker dwellings is consistent with the objectives of Development Policy 9, and it's also a good outcome. We shouldn't allow a definition of a policy to stand between us and a good outcome for people who need it. Our deputation request includes a redrafted Condition 11, which we encourage the DAP to impose. It is reflective of our client's commitment, and it's reflective of the content of the development application that was lodged and approved by the panel.
There are 3 minutes, Mr. Hollingworth, if you can wrap up.
The approach that we've taken is focused on good outcomes. That it removes a significant and unreasonable financial penalty which would otherwise be suffered to our client. And fundamentally, that's the outcome that's prioritised by the policy. Thank you.
Thank you very much for your presentation. Panel members, do you have any questions of this presenter?
You mentioned the key workers aspect, and you mentioned you hadn't, in the party that you had to do an agreement with, you hadn't, is uncertain, but it's stated in the policy the Department for Communities and other affordable housing, social housing operatives. Do you know any of those? Or?
We, as part of the initial approach to clear Condition 11, we engaged with the Department of Communities, the Department of Housing, Foundation Housing, and Nesty Community Housing Group. We spoke to all of them on the notion of a lease outcome, which might see our client retain the dwellings, they take a lease and then lease it on. That was consistent with the initial engagement that we had with the city, that they would like to see the housing operated or managed by a third party. When the address of the development was confirmed to all of those providers, they said, you are captured by Development Policy 9, you are obliged under that policy to sell us the dwellings at a rate that is consistent with the construction cost chart. They had absolutely no interest in an outcome that is what we proposed, being subsidised key worker dwellings, and wouldn't engage in a conversation about an operational engagement with them.
But you would agree it's not their role to clear the condition, is it? They are there to discuss that with you, aren't they?
Well, I think that that's fundamentally one of the issues that we have with the condition. And there's a question of, is it lawful? And we say, well, firstly, no, it isn't lawful because it requires, as you say, a third party to take an action which is beyond our control. But ultimately, what we would like to do is facilitate an outcome which sees the affordable housing provided to key workers.
But the key workers aren't mentioned in the policy, though, are they?
The key workers are mentioned in the objectives of the policy.
Okay. You said that these third parties aren't known, but you do know them up front, don't you?
Well, no,
They're
because
identified in the
they're not
policy.
able to be defined because the policy says or another not-for-profit or another government agency. So they may be known if we could itemise and identify every single one of them, but fundamentally for the purpose of clearing the condition isn't specific in saying it will be cleared by.
No, but it's cleared by the responsible authority, not those
It
parties.
requires the action of an unknown third party.
Right. Going back to the cost base of 2016, in doing your feasibilities, which cost base did you adopt to do the owners, the proponents? Did they not use the cost base of 2016 in doing their feasibilities? Because that's the only respite that they get.
I'm not sure I quite understand the premise of the condition. In undertaking a feasibility of a project, you would have regard to the current construction cost, and the policy reflects a construction cost which everybody would agree is not current and is not accurate. The policy also provides for the review of the policy to make sure that the construction cost is reflective of the financial burden which might be imposed on the applicant.
Wasn't the answer I was seeking. In doing a feasibility, would you not look at the parameters that are set by the planning framework or development framework that says you adopt a 2016 for the purpose of negotiating?
That's fundamentally assuming that policy is a statutory mechanism and is law. The policy provides several alternate and flexible outcomes. And so through the determination of your feasibility, you would have regard for the inherent flexibility that is embedded in a policy. I don't think that it's reasonable to assume that outdated, irrelevant construction costs will not be updated or reviewed consistent with the provisions of the policy.
Okay. So how does, in your opinion, I'll discuss that with council. Sorry, go on.
Any other questions?
Not at this juncture.
I have a few, Mr. Hollingworth. Your proposal, and you've sort of gone there a bit in your presentation, but I'd like you to respond to this question. Your proposal is essentially asking for this development to be treated differently from all the other residential developments in this precinct. So what, in your view, is a compelling reason for this DAP to treat this situation differently?
I think fundamentally it isn't being dealt with differently. It's being dealt with in a way that is consistent with the principles of planning law, that policy is flexible. And if we adopt the position that policy isn't flexible, then it becomes statute. And that simply isn't the case. So I don't think it's necessarily correct to say that we're being treated differently. And in any event, Development WA through the city is confirmed in the Subiaco Redevelopment Authority in applying the exact same policy, has dealt with it differently and has provided a mechanism where subsidised key worker accommodation can be provided in an alternate mechanism. And that's inherent in the way that the policy operates, is that it's flexible and it needs to be provided in accordance with the outcomes that it prioritises through the objectives. It isn't the slavish application of policy that will provide for those good outcomes. And equally, in emphasising the flexibility of that policy, I'd refer the panel to the in-contro development that was approved by Development WA at the former Wembley TAFE site within the city of Subiaco's jurisdiction, when an application for 41 townhouses, Development WA accepted that the policy wouldn't apply at all to that initial development application. There has been the delivery of 0 affordable housing in that development has been delivered. The affordable housing provision in that instance was transferred to a subsequent development application by way of condition. And again, simply emphasises the fact that policy is flexible and needs to be applied flexibly in the advancement of the objectives that are prioritised.
Thank you for that. Did you or your client consider seeking a SAT review of condition 11 following approval last August? If not, why not, given the concerns you're raising now were arguably present at that time too?
We didn't seek review of the decision because our client is committed to delivery of the social dwellings. The development application that we lodged acknowledged the policy and says we would provide the affordable dwellings in the manner of subsidised build-to-rent dwellings. We say that that's the basis upon which the city's alternate recommendation was prepared, and it was embedded in that condition that there was an acceptance from the panel that that's how it would be imposed. We then engaged with the city on the clearance of the condition in a way that was embedded in the development application, and we met resistance. It was that resistance that caused us to investigate the lawfulness of the condition. On that basis, we provided to you an alternate condition that we're very happy with. We would encourage you to impose, and actually provides for the outcome that was included within our initial development application, which was ultimately approved by the panel. I want to emphasise for you today that we're not trying to get out of providing it. We would like to provide it. It was included in the original development application that would be provided as subsidised build to rent. We say that's the basis upon which the approval was granted. We would implore you to move the alternate condition that we provided to you. We think that there's a fundamental error in the way that the policy is being administered. And I think that if it isn't investigated and reviewed by the city as part of their review of their policies, I think that there's going to be fundamental issues moving forward. But in my mind, our client has volunteered an alternate condition which satisfies the policy and provides the same outcome to the people who need it. Fundamentally, the only disagreement between the city and us seems to be whether it is or isn't sold to a third party at a highly discounted rate.
Thank you, Mr. Hollingworth. That's a good segue into my next question. So if the DAP were to agree with your suggestion that your client retain ownership and rent the units out at 74.99% of market value, how would you be able to guarantee that your client's property management function would continue in perpetuity? And how would you be able to guarantee that your client's current business would continue in perpetuity?
What we were contemplating is what we have seen in the Subiaco Redevelopment Authority dealing with the same approach is the application of restrictive covenants over the certificates of title for each of those dwellings. I obviously can't speak to whether or not my client may or may not at some hypothetical point be insolvent, but it's a hypothetical outcome which is difficult to comment on.
Thank you for that. It is hypothetical, but it could potentially be a scenario that needs to be faced down the track. So I guess I asked that question, what would happen in a scenario where your client is no longer able to own and manage the 6 build-to-rent units as you currently propose?
Ultimately, I think it would depend upon the circumstances at that time. A restrictive covenant would continue to apply to that title regardless of who the owner was, because we would see that the city would be a party to that restrictive covenant. So ultimately, whether that apartment was sold to somebody else, that would still be bound by the criteria embedded within it.
Just to close out that, so if that were to occur, would the city need to assume the property management function while your client sorted out their business if it ran into?
I think that would depend upon the terms of the restrictive covenant that would be imposed on the title. Certainly, we have provided for within our alternate condition annual reviews of auditing reports if the city considers that they would like to undertake that compliance role as it would for any other application.
Thank you, Mr. Hollingworth. That's all from me. Local government officers, City of Subiaco office.
Sorry, I just have a follow-up question on that, if I
Yeah,
may,
Mr.
through
Coulter.
the chair. Mr. Hollingworth, you mentioned that a restrictive covenant would be required, yet that doesn't appear in your condition. You make no mention of a restrictive covenant in your alternative condition.
It may have been an error not included. If you were of a mind to move the condition, we would welcome it to be included.
Okay, and going back to for another one, the City of Subiaco would have to be a party to manage that property Have you discussed that issue with the city of Subiaco, whether they're set up to manage?
I'm not sure I
properties like that?
agree with the characterisation that they would be involved in the management of it. They would be provided with annual reports and audits that satisfy the criteria within that policy, and that they would review those as they would like to, as they would with any other compliance action on any other development application. If a approval was granted for anything else, there is a compliance role that the city undertakes in respect of screening, for example. That's not to say that engagement with the city is unreasonable.
I think there would be a fundamental difference between screening and monitoring day-to-day management of property. But anyway, thank you very much.
Thank you. Anything further? No?
Not at this juncture.
City of Subiaco officers, would you like to respond to any of the presentations made or add anything further? Bearing in mind you also only have 3 minutes, and then we'll ask you questions after.
Thank you, and through you, presiding member. When presented to the October Ordinary Council meeting, Council resolved unanimously to endorse the officer recommendation for refusal of this application. I'll quickly go through the history. So the site was previously located within the former Subi Centro redevelopment area, which was under the planning control of the Metropolitan Redevelopment Authority, which is now known as Development WA. Development WA and its previous authorities have been implementing affordable housing provisions within redevelopment areas for at least 14 years. Planning control for this precinct was normalised or handed back to the City of Subiaco on the 18th of December 2020. The process of normalisation includes the lawful transfer of planning instruments, including development policies from Development WA back to the City of Subiaco for future observance and enforcement. This ensures a level of consistency, allowing planning outcomes to be realised that align with the intent of the redevelopment area itself. So the state government has a number of initiatives to facilitate the provision of affordable housing throughout the state. This is often supported by the planning system, particularly in declared redevelopment areas through the MRA Act 2011 and facilitated by Development WA. The current landowner purchased the site in July 2016, and since then they've obtained 2 development approvals, one in 2017 from the MRA, which included the provision of 5 affordable dwellings, and again last year by DAP, which included 6 affordable dwellings. I'll quickly touch on DP9. One of Development WA's development policies that applied in this precinct was DP9, affordable and diverse housing. DP9 requires all development proposing 10 or more dwellings to set aside 12% of dwellings for affordable housing. The transfer of DP9 into the city's planning framework means that DP9 is considered a local planning policy under Local Planning Scheme number 5 and has full effect as such under the Planning and Development Act, Local Planning Schemes Regulations, through clause 85C of LPS 5. Performance standard 3 of DP9 states that the authority, which in this case being the city, shall at its discretion determine the housing types to be provided. There is a clear pathway for the developer to provide for affordable housing in accordance with DP9 through the providers such as Department of Communities. In 2023, for the Form 1 application, the applicant made it clear that they were in discussions with Department of Communities. The city was and has been flexible in the type and manner which affordable housing is to be provided, but only if it is provided by a legitimate housing provider in accordance with DP9. The construction cost chart prepared by DEV WA in 2016 remains current and has not been updated. That is the state government, not the City of Subiaco, stating that the 2016 data is reflective and accurate and it's fit for purpose. Had the applicant sought an alternative approach to satisfy DP9, this should have been addressed in greater detail as part of the Form 1 application last year, particularly if it demanded the exercise of discretion, that is going outside of what the DP9 provisions allow for. This remains open to them through a Form 2 application to amend the condition. So you've got legal advice from the city's lawyers in relation to the appropriateness of the condition. And I'd strongly encourage the panel to agree with the city on this one.
Thank you very much. Panel members, do we have any questions of the local government officers?
The applicant's planner said that there was a previous application for affordable housing that's transferred across to another site. So this particular application didn't have to provide it. Is that correct? Do you know the detail of that?
That would be probably a development WA approval.
Okay.
So it's not something the city would have been responsible for. I've heard of development WA transferring the requirement for affordable housing to different lots if it's in the same ownership. There's one example in City of Subiaco, where Cedar Woods was a developer, and their requirement for affordable housing was transferred from a townhouse development into a larger apartment development. And that was
So
secured through a legal
in total, did the original site and the secondary site provide the 12% for both sites?
Yeah. So that basically, there's a legal agreement in place to secure that in the future. But that's
Okay, so
not
that's
what's being
changed. And you had discussion with the applicants in the original DA for key worker accommodation?
for this application.
Yes.
No.
Was
Not
that
for key
mentioned at
worker.
all?
No,
or-
so when the Form 1 application for this one,
Yes.
back in 2023, the applicant said that they were in discussions with the Department of Communities for a build to rent option. That's what they put in their
But
application.
not for key worker accommodation. That appeared later. The reasonableness of requiring applicants to adopt or accept a 2016 cost. I mean, I don't think anyone in this room would agree with the fact that asking someone to pay for or provide development at 2016 costs, I think. So what is the mechanism, or who goes through the process of updating those costs, and how are they updated, and when are they updated?
Yep, so the DP9 sets out a definition for construction cost chart, just bearing in mind that this is a development WA policy that
Well,
we've.
council's got it now,
Yep,
so you
council's got
should
it now,
know
yeah.
the mechanism.
Yep, so the definition says that the MRA would do the updates. Obviously, we got this policy in 2020. There wasn't an update since 2016, and Development WA hasn't said that they're going to look to update it.
So
anytime soon.
Development WA is the responsible authority to update it.
Yep. I mean,
So-
the city could, but the development, we've taken advice from
Could the
WA.
applicants as a landowner have approached Development WA and said, hey, listen, that seems unreasonable. Can you update it?
Yeah, I mean, I guess anyone could ask them if it's relevant still. But if we're being told by Development WA that 2016 data is still current and relevant and applicable, I don't think the city's in a position to question
Well,
that.
I mean, you can ask anyone whether it's sort of applicable, and it's just unreasonable to accept that to be applicable in today's day. Now, the council's had it for 4 years now.
Correct.
And made no steps to approach or update it. Have you had other applications in that 4-year period that relied on that 2016 costing?
Probably one or two. I think this might only be one. It might be maybe this one.
And did those applicants query the 2016?
No.
Okay, thank you.
Anything further from the panel for the city?
Not this stage, no.
Councillor Wright.
Yes, there's some references to the need for policy flexibility on this in terms of how this is implemented. What considerations to alternative mechanisms did the city give, and do you have sort of what was your assessment of those in the end?
Yeah. So as Mr. Hollingworth pointed out, there was some discussions. I think it was around May or July of this year, just to discuss the potential clearance of that condition. And one option put forward by the applicant was to provide for key worker accommodation, and we considered that in depth in accordance with the policy. So just bearing in mind that the policy is quite rigid in a sense that the affordable housing has to be provided by an affordable housing provider. So the discussions with the applicant before this Form 2 was lodged was that they would retain ownership and they would rent it out through their rental arm of their property management team. So we looked at it as officers, and it did fit within the policy provisions. So as I said in my little statement, it is open to them to seek an amendment to the condition, and we would consider that in the context of what the policy provisions are. But there's not much flexibility in the policy itself. It's quite clear that the affordable housing is to be sold to a housing provider. There's no other option.
The term key worker it seems to have come later in the discussion around these things. How do you understand the term? Who is a key worker? Is it a doctor, for example? Is it yeah, could you help me understand what a key worker is?
Yeah, no worries. So the policy does define key workers. Interestingly, it does mention key workers only in the objectives of the policy. It doesn't actually provide for in the performance standards. So key workers, I'll just read the definitions. Key workers are those people employed in occupations that provide essential services are necessary for economic growth and the vitality of an area. Many key workers find it difficult to access appropriate accommodation in areas close to their workplaces, leading to potential labour shortages in areas with high property prices. This can constrain the economic and social growth of areas such as Subiaco.
So as a quick follow-up, what I'm trying to understand is then, if social housing and affordable housing is, to what extent do we see it synonymous with key worker? Are all key workers also requiring affordable housing?
Yeah, so I think that the policy would allow for key workers to access affordable housing. I think the sticking point is that the affordable housing, as per the policy, must be sold to an appropriate housing provider, who can then use that housing to provide the key worker accommodation.
Thank you.
Councillor Connor.
Thank you, presiding member. The alternative condition 11 that has been proposed here puts the city in a position of being having a compliance role. Is there any precedent for that within the city? Is the city set up to take on that responsibility?
Thanks for the question and through you, presiding member. So we didn't get a regulation 13 request, so we haven't considered this particular condition in detail. I guess first and foremost, as I've mentioned, we have inherited the planning framework from Belmont WA. We are, as a local government, we aren't necessarily geared or positioned to provide for housing and housing oversight. Yes, we have a planning compliance team that can ensure compliance with planning conditions, but sometimes it can overstep the mark a little bit in terms of what the local government is responsible for. So we have had a quick review of the draft condition. We've got a number of concerns with it. Firstly, the applicant's referencing costs relative to rental costs within its own development, not more broadly in terms of what the market's doing. I guess just we're not really sure how we'd actually enforce this condition as well. So yeah, but again, if we got this as part of the Form 2, we could have spent the last 3 months considering this in detail.
Thank you. Any other questions of the city officers?
I do just have one follow-up. Does the policy, or are you aware whether the Department of Communities and other affordable social housing providers define key workers in their clientele?
Thank you, and through you, I'm not sure. I haven't had those discussions with Department of Communities or other providers if they have a different definition. Traditionally, within Development WA areas, it's Department of Communities that has, I think they've got an MOU with Development WA and Department of Communities, which sets out a process to execute, I guess, this requirement through its EP9. So I'm not sure if there's any alignment in there regarding key workers. But obviously there's other housing providers that could satisfy the elements of this particular policy.
Okay, thank you.
Thank you. Any more questions?
I have a question, but not to the city officers, to the applicant.
Hollingworth, would you like to step back?
I'm specifically referring to, sorry, I'll wait for you to sit down. I'm specifically referring to the proposed solution, which is the alternate condition 11. And I'd like, and I don't know whether it's yourself or whether somebody else in the team can provide those comments. Could you explain further the details contained in your condition? And I'm particularly interested in the A, B and C calculation, noting that a number of providers, particularly through the agencies, have a mechanisms that relate to, there's a whole set out mechanism for determining who is eligible, and they are used very clearly specified in various documentation. Can you explain how this works? It appears to be set obviously against rental rates in the same development, not first in the area, and two, there is no information about eligibility criteria. Do you have any information or knowledge in relation to how this works in the context of what the condition is, the existing condition is attempting to achieve in terms of affordable accommodation?
I think in the first instance, the condition, if it was moved, would likely benefit from a slight adjustment to include reference to an operational management plan that could be cleared by the city, for example. So there's some mechanism for comfort around eligibility criteria. We have already interrogated that element quite substantially separately to this and identified eligibility criteria that are industry standard that deal with income thresholds for individuals, families and couples. And those eligibility criteria could be embedded within the operational management plan. To go to Councillor White's previous comment about whether or not key worker and affordable housing, that type of thing, are synonymous with each other, I think to some extent they would operate in tandem. The operational management plan could identify who is a key worker and then identify the relevant eligibility criteria to be satisfied. That would then form the basis of the annual auditing reports that would be submitted to the city.
And my follow-up question to that is, who makes the decision for a tenant under those circumstances? So typically there's, again, quite a specified, it's not normally in a management plan, it's normally in a formal legal document in terms of eligibility. And I suppose it's both eligibility and the order of which someone would actually receive the property. Who's making that decision? I.e., you get 8 applications. Who actually makes the judgment on the individual to ensure that it meets with the provisions that you were just referring to?
Our client operates a rental management company that manages in the order of 100 dwellings separately.
And are those rentals, are they on the open market, or are they
They are on the open market
criteria?
It just goes to their bona fides in terms of the ability to operate and manage a significant number of dwellings. But ultimately, if there were an operational management plan, perhaps combined with a restrictive covenant, then that would provide the metrics against which the ultimate tenant of these dwellings would be assessed against. I'm not sure if your question was, well, if you get 8 applicants, is it first come, best dressed? I'm not sure if that was your question in terms of what's the order of priority, but every person who would be eligible for the dwelling would be considered.
My question is around the approach that's been taken and how that is enshrined in a condition and or a document moving forward. As say, typically these ones that I have been aware of have a specific setting around it, and I suppose some of my questions are essentially around the judgment decision about who is eligible and how that's actually managed in the context of this alternate that you've put forward.
Yeah, if I may add, Adrian.
And sorry, when you're talking about, why is it comparable only to the development and not anywhere else?
As part of when we explored clearing the condition with the city, we did look to, I guess, embed the eligible criteria that would then be considered, whether it's through an operational management plan enforced through the condition or the restricted covenant. If I can, just for context, read you through what we presented as the eligible criteria, because we did do some research around what the other housing providers were including as the eligible criteria. We suggested something to the effect of they would be in a WA-based key worker or industries such as healthcare, emergency services, education, childcare, not-for-profit, retail, transport, or local government, have a household income, pre-tax annual income of between $50,000 to $120,000, not own any property or land, including holiday homes, rental, or a primary place of residence in another location, and be in proximity to the resident's employment. Now, that was the suggested criteria that we would then embed into whatever the agreed document is. Then the property management arm would get any applications, and then this would be the criteria which they would assess and then provide the house to. And that was our suggestion. But and the reference to comparable within the dwelling is from the calculation cost that's embedded within Development Policy 9. Development Policy 9 has two separate calculation metrics. One is the construction cost per the construction cost chart, which is the actual cost of the dwelling plus balcony, excluding land value, common areas, corridors, all of that. And then the alternate is a cash in lieu provision, which we're not able to do. But the calculation in that sense says the average cost of an apartment within that development. So the policy framework provides the four walls, I'll call it, of the consideration of the suitability of the rental or cost metrics. If you're of a mind to expand it to be within the entire city of Subiaco, then perhaps we could consider it. But the concern from my mind is it would likely capture some very expensive properties that we likely don't want to include in the average rental calculation.
Thank you. That's my question.
Councillor White.
Without wanting to engage in any debate, I just would be keen on a comment on, I'm having trouble matching something here, and I'd be interested in your commentary on it. In your letter of 16th of August to the Development Assessment Panel, in which you are asking for more height, the key argument you made was it will increase the provision of social housing by doing that. The thing I'm having trouble matching is now we're coming back with, oh, but we want the social housing removed. Do you have any comment on that?
Yeah, there's two elements to that. Firstly, we don't want the social housing removed. We'd like to provide it. It's just that we don't want to be financially penalised to the order of $750,000 to provide it. We still want to do it, and we still want to provide the dwellings to the people who need it. It's just that we don't want to have to pass on a cost to the balance of the property owners in that building. Separately, the question of justification of building heights and plot ratios, we have maintained from the absolute outset that the planning framework within which this application is considered under clause 32 or 33 of the city scheme specifically contemplates development of 8 stories and a plot ratio of 3 where you achieve design excellence. They're fundamentally separate considerations. We commented on and acknowledged Development Policy 9, but in our submissions, we didn't seek discretion against building height because the city's planning framework already provides for it.
I've got a final comment, a question, and again, maybe somebody else. Can you provide some commentary, planning commentary, on the notion of financial considerations in the planning framework?
It's embedded, I suspect, and Mr. Dobson may be best placed to comment on it, but it goes to the element of reasonableness. It isn't that we're asking the panel to consider the financial aspects of it in isolation. We're asking the panel to turn its mind to what is a reasonable condition and the reasonable application of that condition on the basis of a flexible policy framework that we say the city is applying as if it was law. So if we accept the proposition that the planning framework and the planning law requires you to consider the reasonableness of a condition that is imposed, and the manner in which that condition is being imposed is a $750,000 tax, essentially, that has to be provided before a building permit can be issued, we say is fundamentally unreasonable.
Thank you, that was my question.
Any more questions from the panel? No?
I think,
No, we're all good. Thank you. Yep. Right, let us move to the report section of the agenda now. Can I seek a mover and seconder for the recommendation in the responsible authority of thought? Moved Councillor O'Connor, seconded Councillor White. Would you like to speak to the motion, Councillor O'Connor?
Thank you, presiding member. I'm not persuaded by the arguments to remove condition 11 and the associated amendments from this development application. The policy requiring the 12% of dwellings on this site had to be affordable housing was in place at the time the land was purchased in 2016 when the planning authority was Development WA. The policy reflects the strategic initiatives of state governments over many years to facilitate the creation of affordable housing, and importantly, that affordable housing should be distributed diffusely through our suburbs rather than concentrated in specific areas. Affordable housing is one of the ways of ensuring that suburbs have a diversity of housing stock that caters to and supports a broad range of residents and in turn supports diverse communities. This approach to the provision of affordable housing continues to have community support in Subiaco, as indicated and strongly articulated by the submissions against removing the condition in response to public advertising. I note the Department of Communities also does not support removing this condition. The owners have been aware of the requirements since purchasing the property, and 5 affordable housing units were included in their original development application for the site in 2017. With the normalisation of the area in 2020, the City of Subiaco became the planning authority, and in keeping with the normalisation process, the DP9 policy on affordable housing transferred to the city. Normalisation is a process that has occurred in many other areas that were originally redevelopment areas, and I'm persuaded that it remains a valid planning instrument. I also note that Development WA does not support removing the condition. In their subsequent development application for the site lodged in 2023, under consideration for amendment today, the applicants included an additional unit of affordable housing, increasing the number to 6. Furthermore, the affordable housing was part of the justification provided in the application for concessions that were being sought regarding additional building height and plot ratio. The affordable housing also contributed to the development achieving design excellence. The impact of removing condition 11, removing the affordable housing, is clearly articulated in the RAR we have before us and the other supporting evidence. The development would no longer satisfy numerous parts of the city's LPS 5, objectives for the central zone, planning and development regulations, and obviously DP9. In their submission, the applicant has argued the construction cost chart that's used to determine the purchase price of affordable housing does not reflect the actual cost of construction, and the provision of the 6 housing units will result in a substantial loss. I would note the chart is also linked to CPI, so those 2016 figures are not fixed. The applicant would have been aware of the likely cost of constructing the affordable housing units at the time it lodged its application, and also the likely price at which those units would be sold to the affordable housing provider. It's reasonable to assume that any differences would have been part of their financial due diligence. The objectives of DP9 have been fulfilled in other adjoining developments in Hood Street Precinct, where affordable housing has been conditioned and delivered. And I understand it's also been conditioned on other developments in the previous redevelopment area. I believe this establishes the appropriate nexus. Removing the condition from this development could set an unfortunate precedent for other future development in the normalised area of Subiaco and also elsewhere. I therefore support the recommendation to refuse the application.
Thank you, Councillor O'Connor. Councillor White, would you like to take a second?
Yeah, I'm happy to second this. I mean, I think as a panel, we're required to think about this on planning grounds and what the removal of this condition would mean. I think the RAR sets it out fairly clearly in terms of what the why this should be rejected. You know, it's referred to the fact that by doing this, it would not foster a sense of place. It would decrease the diversity of housing options available in the area. It would not maintain or improve the city's provision of housing choice. It's inconsistent with the planning framework and the Metropolitan Regional Scheme. It doesn't contribute to social amenity, and of course, it's inconsistent with Development Policy 9. I think the issue that we've been asked to I guess, consider is this is no longer the cost considerations of this, and I'm not sure those are considerations that we as a panel need to be taking on board. Indeed, I think that's cost considerations are an issue for the developer in terms of how they are to conceive and to implement a notion of this. I reject the idea that this is a tax in terms of any aspects of costs on this. I think that's a very poor way to present it. I think we're interested in how we achieve quality development within the regulations and the frameworks that are provided, and it's up to the developer to decide. In this case, the developer came with a Form 1 application saying this was how they wanted to approach it. They knew of the provisions, they knew of the requirements, and relied on this in their application and certainly in the presentation to the assessment panel in August. The complaint about lack of flexibility on how this is being addressed, I think, is also something I'm worried about. I think, in asking and understanding how the city staff have approached this, they've met with the developer, they've considered the range of alternatives that could be there, and I think to suggest after that consideration that they don't see this as being feasible and for this therefore to be seen as inflexible is not the same thing. So I think we have heard and read about the various considerations that the city have given in terms of possible alternatives to this, and I think therefore that that's not the same as flexibility. And I think the fact that what we're seeing is what's being presented so far is not feasible in terms of what could be done in terms of if the condition was removed. It is not the same thing. So finally, I think this issue of is the requirement reasonable or not. I think we've certainly seen that it would argue that it is reasonable, that it's something that was clear from the outset that the applicant knew what they were getting themselves into when they applied, and that there's a degree of certainty that was established with that, and that's why those provisions were made. And in a sense, I see this sort of kind of muddying the waters is trying to make things more uncertain than what they are or what they were when the condition was enforced. So thank you.
Thank you, Councillor White. I too support the city's recommendation. I'm not going to talk about the community need for affordable housing. In my mind, that's irrefutable. I'm also not going to debate the contention that Condition 11 will impact the feasibility of the proposed development. In my mind, that's not an issue for this panel to consider. But in considering the planning merits of the proposal, I think the planning framework is clear and consistent on the issue of affordable housing provision. DP9 is a properly adopted policy under the city's planning scheme, and this policy clearly states that the affordable dwellings either need to be affordable owner-occupier housing or social housing, and that the dwellings shall be sold by the developer at construction cost to an approved housing provider. The other developers in this precinct have delivered on these policy requirements. Yes, construction costs may be different now than they were for the other developers, but that's not a sound reason to delete this planning condition. DP9 is currently being applied to other developments in other areas, and walking away from the requirements of this proposal would be inequitable in my mind and would create an undesirable precedent for other areas. The developer bought the site when DP9 was already in play. DP9 was in play late last year when presentations were made to the city's design review panel and the DAP committing to the provision of affordable housing. Plot ratio and height bonuses were granted based on commitments made at those presentations, and no SAT review was lodged challenging the imposition of Condition 11. I acknowledge the wording, the alternate wording for Condition 11 that the applicant has suggested or requested, but I don't support that solution. In my mind, it's that solution that lacks certainty. Now, can there be certainty that the developer's property management arm will still exist years from now, or that the ownership structure will still be the same? I feel we're cobbling together a new condition on the run a little late in the day, the implications and consequences of which may be unintended, and we've not had adequate time to research what those will be, and that creates too much uncertainty in my mind. The city's responsible authority report, the advice provided by McLeod's, in my view, are well reasoned and give me comfort that Condition 11 is a valid planning condition and should be retained. I'm of the view that to delete it would render the proposal inconsistent with the current planning framework, the city's planning scheme, DP9, Principle 9 of SBP 7.0 and the intent of the city's local planning strategy. I will therefore vote to refuse the request to delete condition 11 and amend the development plans accordingly for the reasons mentioned in the report. But I would like to move an amendment to include some additional reasons, and I'll read these out before I seek a seconder for the amendment. Reason 6, the applicant was fully aware of the city's affordable housing DP9 when it lodged its development application last year by marking 6 affordable dwellings on the development application plans that it sought DAP approval for on 21 August 2023. Reason 7, condition 11 imposed on 21 August 2023 fairly and reasonably relates to the development applied for on the factual basis that point 5.5 of the applicant's development application report submitted to the DAP and received on 11 May 2023 states that the proposed development provides diverse housing in accordance with the performance standards of Development Policy 9. Reason 8, deleting condition 11 would create inequity and an undesirable precedent for future developments that fall within the remit of Development Policy 9, both in the city of Subiaco and in other redevelopment or normalised redevelopment areas. Do I have a seconder for that amendment? Seconded, Member Coltas. I've already spoken to the matter at hand. Do you have anything you'd like to add a second?
Well, just speaking to the amendment, I think it's fairly clear. Speaking to the overall development, I'm not satisfied and convinced by the applicant's argument. The development policy is well founded. It's been consistently imposed in the area. It provides for diversity of housing, and the developer was well aware of the policy and indeed made commitments at the development application stage to implement that policy. The alternative condition that's proposed is loose in its drafting and hence introduces uncertainty. So I will be opposing the application and supporting the recommendation with the amended conditions.
Thank you. Would any other member like to talk to the amendment that I have proposed?
I will speak to the amendment. I suppose my starting position is that I acknowledge that policy positions are a due regard and shouldn't slavishly be applied. However, given consideration of the merits of this proposal, and in particular, I'm referring to the conditions that have been read out by the presiding member about affordable housing and the components of the application and the considerations for that application. I'm comfortable that the additional conditions that have been requested or have been amended for this proposal are relevant in the context of this development on this site. My general comments, I'll speak further in relation to the substantive motion, but I don't see that these are inconsistent with the proposal, the recommendation, the substantive recommendation, and that the amendments are clarifying the extent of the applicability of and consideration of the provisions of the affordable housing DP9.
Thank you. Does any other member wish to speak for or against the amendments that are proposed? No. I might put that amendment then to the vote. All those in favour? Carried unanimously. That amendment now forms part of the primary motion and we will revert to the primary motion. I have already spoken on it. Does anyone else wish to speak now on the primary motion?
Yes, I will speak, member. I've already indicated that I agree that our policy position is a due regard and should not let slavishly be applied. I've considered the material that's been presented both in the RA, including the legal submissions that were included with the RA, as well as the additional material. I understand the issues that have been raised clearly, and I am of the view that the existing condition 11, and I suppose my considerations are twofold. One, is it legal? And two, is it reasonable? And so there's a merit-based consideration of it. From my perspective, I am of the view that the condition is legal and is valid, and I as has been mentioned today, I would concur with the reasoning that's been provided through the McLeod's documentation. From my perspective, it is a valid condition. In terms of reasonableness, I also concur that it is reasonable. It's reasonable in the context that the policy position is, in this particular instance, relates to a specific provision for affordable housing. And in this particular instance, the matters of economics, I'm not satisfied that the arguments put forward in relation to the economic considerations hold substantial enough weight for me to discount the relevance of the condition. I'm also of the opinion that, as has been mentioned already today, that the alternate condition put forward, I have a significant number of concerns in relation to the detail that's contained in it, and I would concur with the comments that have been made in relation to the certainty that sits around it and the controls that sit around it, much of which are left in a much greater sense, left uncertain and require substantial alternative involvement. I also note that there is a series of mechanisms that would require the city to be heavily involved in the ongoing management of it, and I'm not convinced that the documentation that's been provided to us today has appropriately explored that in any way that is acceptable. From my perspective, I am comfortable that the condition as written in the with the additional amendments and reasons is suitable for this development. So I don't support change to that condition, and I'm not satisfied that the information provided has adequately swayed me to remove or replace the condition with the alternate proposed solution, as primarily for those reasons.
Thank you. Would any other member like to speak for or against the primary motion as amended? No. Councillor O'Connor, as the mover, would you like to close?
I think everything has been said. Thank you.
Nothing further. In that case, let's put that recommendation to the vote by a show of hands. All those in favour? Carried unanimously. Thank you. Item 5 in part B of the agenda is section 31, SAT reconsiderations. There are none. So we will move to part C of the agenda. Thanks to those who have been in attendance for the Subiaco item.
Oh, see you. Moving on.
Welcome back, Mayor Rossi. Can you hear us?
Yes, I can.
Excellent. Thank you very much. Moving then to part C of the agenda that deals with the City of Belmont item. Could I please confirm by a show of hands that all panel members have duly considered all the documentation contained within Part C of the agenda and Part C related information? Thank you. Item 2, disclosures of interest. Could I please invite members to declare any declarations? Do you have any declarations? Mayor Rossi, has this matter been before in a council? No?
No.
Okay, great. Moving then on to the item, Form 1 application, item 3.1, lot 753, number 205, Great Eastern Highway, Ascot, mixed-use development, hotel, service apartments, restaurant and small bar, DAP number 24/02699. We have had 3 presentation requests for this item, and the presenters in the room and heard my little speech on this before. I need to remind presenters that we have reviewed all the documentation you have submitted, so probably no need to go over that again. But in accordance with 4A2 of the DAP standing orders, your presentations are limited to 3 minutes, so use the time wisely. I'll give you a heads up when you're nearing the end of your allocated time, and panel members will be invited to ask questions of you after each presentation. I believe we're starting with Laurie Scanlon. Please come forward, Mr. Scanlon.
In the time allowing us to come and speak. I just wanted to give some background information to what we had earlier presented, and as you said, we were asked some 15 months ago to be part of the team to develop the site on behalf of my client. At the time of the initial investigation of it, my client's brief was to prepare for a very, very high quality hotel in this area. The area itself is very not well developed in terms of quality product. And even though that was evident, his desire was to build a first-class quality 4.5-star hotel on this site. We had an international operator, Wyndham Hotels from America, as an operator on board. His desire was to prepare this development very quickly. So our first part of our brief was to investigate the site and to analyse it in such a way to be able to give him that assurance that something could be developed compliantly and achieve his outcome and his scope. In doing that investigation, clearly we had further input from our own planners, but more importantly, we investigated the site and had a look at it. And our first part of the quest was to make sure that it was not only compliant, but it was something that the surrounding neighbours could actually be, would also be supportive. Part of that was looking at the bulk scale and height, and also the orientation. So what we did show you today in that we looked at was relating to that investigation right at the beginning of the project some 15 months ago. We looked at it, and it was all about bulk scale and overlooking. So what we had shown you in the previous submission, that if you look at the development in such a way that it, that's what this alternative operation. If you do consider this as an alternative, which may be more in keeping with what the council of the city is now sort of encouraging us to investigate, we looked at these submissions, and quite frankly, the outcome for the neighbours and the area in general, we felt was a very bad outcome. So the overlooking situation on your neighbours, and also the bulk, and so even that building there is this new location. That's actually 3 stories lower than what's being considered by the DAP today. So even that 3 stories lower, the massing of that building and its relationship to the neighbour is quite excessively more than what's proposed. So the very tall but skinny building with the small extension facing the neighbour was considered at the time, 15 months ago, as the best outcome for all. So it's compliant, it is good for the neighbour as far as I'm concerned, and we felt this was the best outcome. So at this stage, we went to the...
You're at your 3 minutes, Mr.
Okay,
Scott.
we went to the city and we had meetings with the city planners. Again, the city planners, through no concern, there was no objection to height of and the relationship and setbacks. And we got very good feedback from them. We also had meetings with design review panels right through this whole process. We haven't had any objection whatsoever to setbacks and height. We've gone through the design review panel. They've made a number of requests for amendments, and we have done that, and that's the offering that you've got in front of a very high quality development, which we think should be supported.
Thank you, Mr. Scanlon. Do panel members have any questions for Mr. Scanlon?
Yes, I have some questions. My questions are specifically to the proposal, and I thank you for some information about the alternates. I'm at this juncture not focusing at all on those. They're not, as I understand, part of the application that we're making a judgment on. So my questions are specifically about the proposal that is determination to be made today. Can you speak about the following two matters, the interface / transition, and I'm specifically talking to the property at the rear, excluding commercial on the side, and the RSL, which is the non-residential. And my second part of that is, can you talk particularly in relation to overlooking in the context of your design, which includes a lot of windows towards that boundary?
We sort of mentioned, I guess, the two-end apartments or two-end hotel rooms have got corner windows. This is a very minimal amount of overlooking compared to the other orientation. We did have considered that. The podium we kept right down to a minimum. So the podium has been set at about 3.3 metres. Even under a lot of high-rise development now, there's an encouragement to do three-story podiums. We were conscious of that, and what's essentially been put right on the neighbour's property line is a 3.3 metre high fence. There's an existing fence in operation even now, which is a metal colour bond, but that, so we felt very compelled that that long 3.3 consistent fence on the boundary was suitable and certainly would reduce any further objections from our neighbour. The properties out there, as you know, is part of the stables, and whilst they are single residential, there is a commercial activity within the stables area, which we don't know how that will develop. But again, the whole primary thing is to make orientation. So we went to the skinny side. There are rooms facing that direction, but they are minimal, as we indicated in our presentation. We can look at those as far as the downward looking situation. So most of the rooms are designed to have a long distance viewing. So even though the building itself is close-ish, there's nothing we can do about that. It's 3.6 metres away from the boundary. And there are other precedents in the area. So we again, designing it and coming up to that outcome, the outcome of the orientation, we were mindful of other developments along the face of the highway in that area which were similar. So we felt again it was compliant, and we've done everything in terms of minimising any overlooking issues.
And my second question, thank you for that. My second question is your last comment. I'm interested, can you explain further about the actions that you're proposing in terms of minimising the downward view, which is essentially obviously into the rear of, or into those actual, the residential property I'm referring to?
So we have looked at that in terms of, that wasn't on the original submission, but we are quite happy to put in case screening, horizontal screening to avoid any downward overlooking of the property next door. I think that would be a reasonable condition with notes that it wasn't spoken to when we were up to design. That could be developed up in such a way that we can move up to the city and the council that we could avoid any potential overlooking down.
Thank you. Those are my questions, Chair.
Thank you. Any other panel members have a question for Mr. Scanlon?
Yes, just quickly, Mr. Scanlon. The last part of your answer there is a condition proposed in the alternate recommendation that major openings on the northwest elevation are provided with screening, with horizontal screening. Do you understand what that means?
Yes.
Can you enlighten me what
Oh,
your intent?
Yes, the objective there, clearly, we do understand what the alternative recommendation is. It doesn't mean necessarily screening all out, but certainly a number demonstrates a horizontal screening to avoid downward skewing. So standing position in the room to make sure that you can't look directly down. So making sure that people can notice the long.
Yeah, thank you very much.
Just a question from me on that condition. So there's been a request to delete that condition, but you're saying you're happy to look at that screening. Are you amenable to amending that condition? Is that a question for you?
Well,
All right.
I asked for it to be deleted. I'm happy to withdraw that request.
Thank you. Okay, any more questions for Mr. Scanlon? Mayor Rossi, are you all good? Okay, thank you. Linda Morich, 3 minutes from you, thank you.
Presiding member and members of the panel, my name is Linda Morich. I'm a planning and environment lawyer acting for the applicant in this matter. You received my written submission, so I don't intend reading that verbatim, but what I wanted to do this morning in the limited period that I have is to take the panel to the recommendations for refusal by the City of Belmont. You'll see that the first the recommendation or the reason for refusal relates to it not being compatible with its setting. And in particular, on page 1 of that agenda says because of its incompatibility with development on adjoining land and on land in the locality. Then the panel turns to page 13 of the planning report that you've been provided with. There is actually no assessment or evaluative consideration of the proposed and future context of amenity of the built form in this locality, which we say is deficient in terms of what is proposed in this area and has been proposed for some time under the planning framework. Over the page on page 15, there is an assessment of the height of this development based upon the existing current statutory planning framework. What concerns me is that the fact that this development is actually compliant with the planning, with the heights that are proposed under the existing scheme, has been embedded in the commentary and has not been highlighted to the DAP. So you'll see at page 15 at the top of that page, it says the proposed height of the building is 54.35 metres above natural ground level, which is below the 60-metre height referral requirement of LPS 15. To be clear, this proposal is compliant with the standards and development requirements that are set out in LPS 15. It appears that the recommendation for refusal has been entirely based on this local, on this strategy that was adopted by the council only last week. And my letter to you has explained why we say that strategy should be given no weight. It is not a document to which weight should be given in accordance with the requirements of clause 67(2). It is not a structure plan. It has not been approved or endorsed by the WAPC. It hasn't been adopted as a local planning policy, and indeed the strategy itself identifies the fact that there's an enormous amount of work that needs to be done in order to implement the ideas in the strategy into the planning framework.
There are 3 minutes.
Yes. So in order for these things to be taken into account, there is much work to be done. There are referrals to be had with other agencies. The commission must be involved. This is a twinkle in the eye of the city and nowhere else at this point. And for that reason, we say no weight should be given to it. This development complies with the planning framework. It is a good quality development, and we respectfully request that approval be granted. Thank you.
Thank you, Ms. Morridge. Do panel members have any questions of Linda Morridge?
No.
No, thank you. Tane Evershed.
Thank you. Good morning, presiding members and panel members. Thanks for the opportunity to speak. Look, there are many reasons to approve this development. It complies with building height provisions of the scheme. The average street setbacks comply, and the lot coverage is significantly less than the 60 to 70% that's allowed. There is no prescribed rear setback for the mixed-use zone. In the absence of any codifiable setback, compliance with other built form measures is a good place to start. And in this case, the development complies. Now, clause 419(1) of the scheme does include general provisions that relate to development along the Great Eastern Highway. The relevant provisions that relate to rear setback and transition are C, the potential impact of overlooking and or overshadowing. Now, as demonstrated in Laurie's presentation, the design minimises overlooking to the rear with half the building facing an RSL. And as Laurie said, we'd be prepared to accept a condition regarding screening. The building's proximity to the rear boundary also encourages long views to the horizon rather than down into the horse stables. And finally, the setback of the building orientates windows to the rear of the stable areas. And there will be no overshadowing. Point D of the clause deals with the potential impact of the proposal on the existing and proposed streetscape. In this regard, the built form was arranged to address each street appropriately with a narrow facade to Great Eastern Highway and a 21-metre setback to the long tower facade of Urrum Street. This building arrangement reduces any impact on the streetscape. And finally, E, the effect of the proposed building on the amenity of adjoining and nearby properties. As outlined in our submission, the stable zone is a quasi-commercial enterprise with housing and the stabling of horses associated with the nearby racecourse, in effect, a home with a working backyard. In our view, the development has been designed in a way that balances the amenity of the adjoining properties with a building design outcome that in fact complies with the scheme. And Laurie's shown you the impact of alternative designs that might be more compliant in the city's eyes. And on the point of design, as Laurie mentioned, the city's design review panel supported our approach to the arrangement of built form and did not raise either the building height, rear setback or transition as an issue. In recommending refusal, the RA relies on the city's recently adopted and heavily modified strategy. As Belinda said, the strategy does not form part of the planning framework and should be given little weight. On the other hand, significant weight must be given to the scheme to which this development complies. The final point I'd like to make is that no submission appears to have been made by the adjoining resident at 15 Urrum Street. And while submissions are one of several considerations in the decision-making process, it's telling this owner didn't object.
You're at 3 minutes, Mr. Evershed.
Thank you. Just concluding, this is a high quality design. It's going to represent a step change for the Great Eastern Highway corridor with a 4.5-star offering. We respectfully request that DAP approve, subject to the deletion of conditions as outlined in my presentation summary, excluding conditions 4. Thank you.
Thank you, Mr. Evershed. Do any panel members have questions for Mr. Evershed?
Yes. Mr. Evershed, you've spoken already about the alternate recommendation,
Yes.
Particularly your submission in relation to either deletion or / amendment or modification of conditions. And I note that you made a comment earlier today about condition 4, which
Yes.
I understand you are not considering.
Withdrawing it, yes.
Yep.
Thank
So
you.
could you speak further on your comments about the conditions? You've got a further 2 that you're seeking to deletion, which is 19 and 20, and you're seeking 18 to be modified. I'd be interested in hearing further your comments.
Condition 19, says that's unnecessarily. We're required to comply with the EP noise regs to run the condition. Condition 20 is not necessary. Through the course of the redesign of the development, the loading area sits in its own sort of garaged area and cannot and will not interfere with car parking bays, which are all in the basement of the development. So that condition is superfluous and unnecessary. In relation to the Section 70A notification, I'll speak to it, but Belinda may also have a view on this. Typically, the purpose of these sorts of notifications is to advise prospective purchasers of residential apartments of the impact of what we're talking about is a hotel development, which is in our view less constrained by the need to notify potential guests of the hotel of the noise issue. Furthermore, we've got an acoustic report that will deal with these sorts of matters through the construction. Belinda, I'm not sure if you have any other comments.
Yeah, I think, look, there's the state planning policy for these sorts of corridors does recommend a Section 70A condition or notification, the condition requiring a Section 70A notification. In this circumstance, very unusual condition to put on a hotel. As Tane has mentioned, it's usually used in the circumstance. Section 70A notifications are used to identify latent defects or latent impacts that might impact the amenity of an area. And so you can understand why you might put them on an apartment building, particularly if they're being sold off plan, so people are aware that they might be impacted by noise. In this circumstance, you've got an operator operating the whole of the hotel, no doubt given its location, not only on a road, but quite close to the airport. There will be noise attenuation embedded in the construction of that hotel to ensure that the amenity of guests is not impacted. I think that it's an unnecessary condition for a land use of this nature.
So could I just clarify, are you seeking to delete condition 18 or
My
modify it?
preference would be to delete it. I think it's unnecessary.
Okay. Other questions from?
Yes, I have a further question to Mr. Tane. Can you provide some further response in relation to parking? I know you have provided some already, but I'm interested in, and I have a similar question to the officers, the calculation of parking using different sets of provisions, one obviously scheme provision and alternately the draft provisions. Could you provide some comments in, and my specific question in relation to parking is why in this location do you say the parking ratios that you are proposing and the variation that's being sought are appropriate? And I'm specifically referring to it in the context of this location, given the road that it's on and the type and nature of the use.
So, look, firstly, the parking rates, the current parking rates applied in the scheme, we say are outdated, and that's reflected in the calculation that's been done against the Department of Planning's recent updates to the parking rates for Perth and Peel, which deliver a 70-bay surplus on paper. In terms of the suitability of the number of bays, there's a traffic report that supports the development, and there is high frequency transport along Great Eastern Highway that can service the development.
Any other comments? Thank you.
Just following up on that.
Sorry, are you specifically referring to the response to the question I had?
Yes, that's okay.
I would, so if you don't mind, I would be interested in you making, if you're okay to make some further comments.
Well, because we had a operator in the hotels involved, and they have got vast experience in running their own hotels and what knowledge they have in terms of the car parking requirements, we embraced their input, and we, as part of our submission, put a letter from with the hotels. And as far as they're concerned, we had more than enough car parking, in fact, too many. So the operator itself, who has the most experience about what car parking needs for this hotel, has indicated in writing that.
It should also be noted on the record that this is the first 4.5-star hotel immediately near the airport. So one would imagine that it will be used, quite frequently for layovers between domestic flights onto international flights, et cetera. So of all locations where one might consider a variation in car parking, something so close to the airport is, we say, acceptable.
Mr. Coltaz, you had a question?
Yes, Mr. Evershed, you said that the WA Planning Commission parking standards on Perth Peel have changed. And I think that's it said it would attract how many under their standards, a requirement for?
I'll produce a 70 bay surplus based on the number of parking bays that are proposed.
And I think the standard was developed on the basis that hotels are tourist orientated, have tourist buses and people coming from the airport, and that a lot of the standard for, let's say, a motel, which this would also apply to, would probably drag in a higher requirement normally under Belmont standards. You said they're outdated.
Yeah, I think in this location, you're probably less likely to get that type of motel style of development. The intention of the city's existing planning framework, which encourages height, and certainly their new strategy is to see a very different type of built form than that motel thing. And it may well be that those car parking standards of the cities haven't kept up with their ultimate intention with for the built form in the area.
Okay, thank you.
Mayor Rossi, do you have any questions of the presenters?
Yes, please. Thank you. Just going along the same line of parking, my question is, parking may be outdated, but isn't that what we should be applying? You've mentioned that it was outdated, the standards, but isn't that what we should be applying?
Well, the scheme does provide for discretion to be granted under certain circumstances. And what we're saying is that there are more contemporary parking rates through the draft guidelines that the WAPC has provided that provide a greater analysis of what is an appropriate level of parking. When you combine that with the things that Laurie has said, which is we've got an experienced operator that's identified this site for a specific purpose and reason, and confirmed the number of parking bays that are being proposed are more than sufficient to support the development, along with Belinda's comments around the likely use of this development by people coming off planes and staying here, in combination with the high frequency bus and rideshare opportunities that short stay accommodation offers, then it is our view that discretion should be given for the parking proposed.
Thank you.
Any other further questions? I have a brief one. Did your client make a submission to the city when they advertised their draft strategy?
When the submission when the strategy was advertised, we certainly made a submission to council. So when the strategy was advertised, I don't recall we specifically made a submission, but when the strategy went to council for final adoption, I think 3 days before the RA was due, we made representations to the council, both written and oral, flagging with them that the modifications, that considerable modifications that are made to the strategy from advertising to adoption shouldn't be done without going back to further advertising. We made the point that in the interest of procedural fairness and natural justice, that the council shouldn't be making such dramatic changes without going back to all of those affected by it. We put them on notice and they disregarded that and adopted the strategy. And I think that bit of highlighted bit there is the bit that was in the strategy that was advertised, and that's what they adopted, and they adopted that without going back to the community for further comment. And that's part of our concern that Belinda's raised, is that we've got a strategy that includes a whole range of changes that should have gone back to the community, and on this and further comment.
Thank you. Okay, local government officers, would you like to step forward? Thank you to the presenters. City officers, you're able to respond. You have 3 minutes to any of the issues that have arisen through the presentations or otherwise, and then I'll invite questions of yourselves.
All right, thank you, Chair. I'll perhaps do a short introduction just in response to some of the submissions or points made by the applicant. Firstly, I understand that all parties have the opportunity to review the city's responsible authority report. I believe this clearly outlines the city's position. Firstly, the city considers that the core issue is the proposed 15-story height with a 3.5 meter setback to the adjoining dwelling, which is zone residential and stable zone. We consider this presents an unacceptable transition, which is reflected in the recommended reasons for refusal. First reason being is that this is a development that is not compatible within its setting. At its core, there is, I reiterate again, a single house on 15 Oram Street to the north with an adjoining 15-story development with a 3.5 meter setback. I'd like to draw the panel's attention back to the officer's comment under pages 13 and 14 of the report, and under the subheading current and likely future context section. Specifically, this section makes it clear that the current and future likely context of the northern adjoining property will remain as 1 to 2 stories development. Now, there is more than a mere chance of the same or similar development reoccurring, as there is clearly a demand for hotels or similar types of development in this zone along Great Eastern Highway. Therefore, we consider that this proposal is unacceptable. It will create an undesirable precedent. I will now take a quick moment to raise some of the points put forward by the applicant. Firstly, it is understood that Mr. Evershed from Planning Solutions raised a point about the absence of a prescribed rear setback, that the starting point should be compliance with other built form controls within the scheme. Our response to that is, while it is useful to look at those, and we have assessed it against the other built form controls within the scheme, it is important to also consider the individual aspects that we're looking at, which is the rear setback. While there is no prescribed rear setback provisions in the scheme, it needs to be looked at holistically against the matters to be considered in the planning regulation in the scheme. Clause 4.19.1 of the scheme outlines specific matters that decision makers must consider for multi-story developments along Great Eastern Highway. These include, and you would have been aware, the bulk and height of adjoining and nearby buildings, the potential impacts of overlooking and overshadowing, potential impacts of the proposal on the existing and proposed streetscape, and the effect of proposed building on the amenity of adjoining and nearby properties. While these are general matters, thank you. While these are general matters typically considered when planning application is reviewed, their specific inclusion in relation to multi-story developments along Great Eastern Highway elevates their importance and should be given due regard. With regards to the corridor strategy, and I thank you, and I thank Belinda for providing the info on that, and we do agree to some degree that we at no point, or the report at no point has tried to elevate it to a statutory document. Simply, I would like to draw the panel's attention again back to the reasons for refusal, which is not dependent on or reliant upon the strategy.
Thank you. Do any panel members have questions for the city officers?
Yes. The Quest Apartments, what's the rear setback on that development to the adjoining bed and breakfast?
That was, I believe, in the order of 2 or 2.5 meters.
Which is less than the 3.8 proposed. Okay. The height of that development?
That was a 9 stories building.
9 stories. Okay. Did that development get any concessions on parking? Are you aware?
Not that I'm aware of. I'm not privy to the details of that particular development as far as parking goes.
Yeah.
Yeah.
All right. That's all at the moment. Thank you.
Mayor Rossi, do you have questions?
Yes, just one concerning the parking situation. We heard that, well, we've heard comments that they wish to have less. What's your view, considering this isn't that close to the city, and I'm concerned, where will the people park?
So in terms of the car parking assessment, obviously from an officer's perspective, the starting point is the scheme requirement, and we obviously have identified a significant shortfall under the scheme. However, throughout the application, the applicant has provided certain levels of information to assist with demonstrating how they could, I suppose, deal with the shortfall. And this was also, I suppose, the city's assessment was also relying upon a similar development along Grayston Highway, which was previously approved by DAP, and it was specifically along 155 to 157 Grayston Highway. It was established through that particular decision that there was a ratio that was more appropriate based on the occupancy rate. So we ran the numbers through that particular ratio and have found that, because they're both the same use, the car parking requirement was quite similar in that sense. So we thought that's perhaps a better consideration in addition to the scheme provision. However, what we do want to say is, in terms of our assessment, we have not had specific or occupancy data that's specific to this particular site. That's why, if that was inclined to approve it, our recommendations for the inclusion of the parking management plan condition helps fill that gap.
Thank you. Anything more, Mayor Rossi? No?
I have a couple of questions. Thank you, presiding member. My questions are I suppose it's really the weight of consideration. I have various extracts from your scheme. Those extracts are principally under section 4, so it's 411, 419, 420, dealing with the mixed use zone, development on Gracie Highway and height controls. And it also refers to schedule 8, which is the height controls set out in the scheme in that schedule. I'm interested the extent to which weight has been placed on the strategy, which has been, according to the material that I've got, only just been adopted by council, and that there would be significant ongoing actions and timeframes for these changes to be represented in the statutory documents. I'm also cognizant that the statutory documents currently in dealing with height refer to the essentially the airport controls in relation to overall height, and your RA refers to them as being acceptable. So my question in that context goes to the concerns you're raising about in the RA in relation to character and context of the area. And I'm particularly interested because my consideration is that the current scheme provides a context that enables the development of this form. And can you talk through, in particular, why this form is so inconsistent, given that you're on the very early stages and there's no certainty or imminency to any scheme changes?
I'll take the
I
second.
might add to that because it's it'll be part of your same response. I guess there's no height limit in the mixed use zone in your scheme. And you put it's not really a limit, and a height in the strategy, but before the strategy, how did you assess the height of the other buildings, particularly the two hotels? How did you assess the merits of height? And if you can answer that in conjunction with what Member Lafronte has asked.
Yeah, maybe I'll address the point about the weight that's placed on the reasons for refusal. So you would have seen through the reasons of the refusal is written clearly to be based on the matters to be considered under the planning regulation, and you would also note that in our in the Grayston Highway Urban Corridor Strategy section of the report, that we at no point, the city at no point had.
Can I ask, presiding member, sorry, my apologies, but the microphones are really sensitive, so the gentleman's turning the pages. I cannot hear the presenter, so sorry. I know you don't know it. It's just, I'll let you know. I can't hear it.
Thank you, Mayor.
Okay. Sorry.
Okay. So I suppose what I was trying to say is the responsible authority report at no point has tried to draw any reasons or try to rely upon the strategy to support our reasons for refusal. What we will simply say for the reasons for refusal is simply how we don't consider the building in its current form addresses the northern adjoining property appropriately. And in terms of I guess addressing that, it really is focused on that transition there. So hence, we have not, you would have seen in the building height section, we have not taken issue with the overall height of the development across the site. 15 stories and the maximum height that they've proposed across the site, we deem to be, appropriate under the current scheme provision. However, at that particular rear interface, we consider not enough has been done to address the northern adjoining property.
Before I hand back to you, Ms. Lafronte, so would your recommendation have been different than if the building was set back in line with the requirements of your strategy and had been designed at 10 stories?
That provides, I suppose, in the absence of a specific built form control, had that been done, that provides a clear, I guess, reason of good, I guess, an appropriate transition, because the strategy's concepts and suggestions in terms of built form, that was done with an analysis of what is, I guess, a reasonable or good planning principle when dealing with properties that have two distinct built form requirements.
Back to you, Ms. Lafronte, to conclude your questions.
No, I'd probably leave it to my comments.
Okay, thank you.
I just have another question, presiding member. In the context of your answer there, then how do you rationalise the setback for the Quest apartments? If the height's not an issue, and you're talking about a setback and a transition, I'm presuming that the Quest apartments are mixed use as well. So
I believe it's a service apartment, but I guess if we're talking about the built form, the land use probably doesn't have to.
Do you have the same consideration for that though, with a 2.5 metre setback as against the 3.8? I'm just trying to see the consistency in application.
Yeah, again, I can't speak in detail to that particular application as it predates my employment at the City of Belmont. What I can say is perhaps through the development such as the Quest apartment has
along the way highlighted the importance of developing this strategy further to specify and include some suggestive concepts and diagrams to assist future development on what aspects they could consider to appropriately transition to the rear. Now, these are just concepts in the strategy, and the strategy is we agree that there's no statutory weight to it. So we like to really bring it back to the reasons for our refusal, which is based on the matters to be considered under
There's just a rear setback.
Yeah.
My question, thank you, Member. My question is specifically in relation to your scheme. I know that your current scheme has a use class classification of residential, also has a use class, a zone, sorry, not classification, zone of residential and stables. Could you talk a little bit further about the not so much the difference, but there's obviously a conscious decision to separate out a residential zone from a residential and stable zone in terms of the type of uses that would be permitted. And then can you express some further comments about this concern about the interface? Because I see you've actually separated them out in your scheme. Quite clearly, the intention is that they have different amenity considerations.
So in terms of residential and stable zone, that perhaps was the zone probably perhaps have been established on the basis of the surrounding areas being stables property that supports the Ascot racecourse. So as far as, I guess, land use consideration goes, while yes, it's quite clear that the zone is distinct in its own manner to accommodate stables type land uses or land uses that support stable, I suppose the key component with this zone also has the residential aspect, which is no different to your normal single houses. I guess from a built form perspective, the difference here is that you often would have seen it's a big property because they've got their houses at the front and then stables at the back. However, what we say today as far as amenity consideration goes is there is still the residential aspect and on some level does deserve that consideration to their residential amenity. So they still have their outdoor living area, notwithstanding they have their stables beyond the outdoor living area.
Thank you.
Thank you. I have a few quick questions before we go to the report. So it doesn't appear that the amended proposal, the redesigned one, and all the additional information that was provided was referred back to your design review panel. Is that correct?
That's correct. Yeah.
Okay, is that standard practice that you only send it once?
No, through the chair, it's not our standard practice. So if there has been substantial change that warrants where if there is a substantial change, that's when the city would certainly bring it back to the design review panel.
Okay. Thank you. Condition 5 refers to a landscaping plan that needs to cover, this is assuming those even get some airtime, needs to cover all areas visible from the street and communal open spaces. Are the green roofs shown on the plans all communal open spaces? And if not, should those areas be included in the condition? They still need to be maintained, etc. So if you look at condition 5, if this was to enter the conversation during the report discussion, it doesn't reference those green roofs at all, and I'm just wondering whether it should. Maybe at the end of 5A, communal spaces and green roof areas.
Yeah.
Your comments on that?
Through the chair, I might just jump in here. That's okay. I think 5C does talk about details of plantings on structures.
Okay, and you feel that that adequately covers that?
I think that's what it was referring to, yes.
Okay, Thank you for that. Condition 25 requires a geotechnical report. That's a little bit unusual for a development like this. Is there a specific reason this has been included?
I might just jump in again, thanks, Chair. That condition was requested by our infrastructure. It's purely for looking at stormwater, particularly when there's basement levels. It's a condition that's often before the city.
Okay. All right, thank you. I think those are all the questions that we have of you. We might move to the report now. Can I seek a mover and a seconder for the recommendation in the responsible authority report, noting that the recommendation is for refusal of this application? Does anyone wish to move the recommendation in the RA? Moved, Councillor Rossi. Do I have a seconder for that recommendation? No? Okay, then the problem that recommendation will lapse. I would therefore like to move the alternate recommendation to approve the application, but I would like to amend some of the conditions. I note, and before I move into the merits of this and ask for a second, I just need to make clear what the amendments are that I'm seeking. I note the applicant has said they're happy to delete or to retain condition 4, but I'm wondering if that should be amended slightly to remove the words prevent direct and to insert the word minimize overlooking. The other amendment, as per the applicant's request, is deletion of condition 19, which refers to noise legislation. Deletion of condition 20, which refers to unloading and unloading and use of the car park. And modification of condition 18 to require the notification prior to occupation instead of applying for a building permit. Do I have a seconder for the alternate recommendation with the proposed amendments I've outlined?
So your amendments, if I may, through the Chair, that you're moving the alternate, that condition 4 includes a minimise overlooking, that's staying as a condition.
Yes.
Condition 18 stays as a condition with the words occupation, first occupation.
Yes.
And that condition 19 and 20 are not forming part of the motion you're moving.
Correct.
I'm happy to second that.
You're happy to second that? Thank you. As mover, then I will talk to this. The following sets out my reasons for moving the alternate. I think the refusal recommendation was based on setting an undesirable precedent and incompatibility with the setting and amenity, including relationship to surrounding properties. But those reasons for refusal seem to stem from the fact the proposal didn't strictly adhere to a strategy that was only adopted a couple of weeks ago and has no formal status. The city scheme takes precedence over the strategy. It appears from the presentation and from the city's own RA that the proposal largely meets the scheme objectives and requirements. I really don't think there's any reasonable basis upon which to refuse the application, and even if it adhered strictly to the city's new strategy, the recommended reasons for refusal would arguably still apply. So in putting forward the alternate, I agree with the applicant's initial concern about condition 4 about overlooking. The use of the word to prevent direct overlooking, I think is unreasonable, because you're hardly ever going to be able to prevent direct overlooking. So I would suggest that the words prevent direct be removed, and the condition then says prior to lodgement of an application for a building permit, amended plan shall be submitted to address the following. Dot point. Major openings provided on the northwestern elevation are to be provided with horizontal screening to minimise overlooking of adjoining properties. I agree that condition 19 can be deleted. I don't think it's appropriate to place a condition on a planning approval that's covered by separate non-planning legislation. The applicant has requested deletion of condition 20, given the explanation provided. I think the condition will actually be hard to enforce from a compliance perspective for the city. How do you manage or police that condition? I'm therefore also happy for that condition to be deleted. Lastly, as per the applicant's initial request, I think it's reasonable and appropriate to modify condition 18. I note the later request to delete it. I'd probably prefer to keep it because in previous experience I have hotel operators can be notorious about lodging noise complaints about other certain things. I'm not saying this one would, but I just think it's important to retain it on these applications so that if any future sale was to occur or any other hotel operator were to purchase the property, they'd be fully aware about what the noise issues would be. That's it from me. Would the seconder like to speak to the alternate, the amended alternate?
Yes, thank you. I am supportive of the proposal and the recommendation that has been provided. From my perspective, I'm of the view that the proposal is consistent with the planning framework. I will, however, acknowledge the recently adopted strategy, but I have given minimal weight in a planning context to that strategy. As I've already indicated today, there is no certainty of the outcome of those change or those strategy objectives ultimately going into the formal statutory documents of the scheme, and that is a significant way off, and so therefore there is no certainty to such an outcome. In terms of the local area, in the context of the site, I'm satisfied that the proposal is appropriate in its context. Its context is along Great Eastern Highway. It's a very busy road, a very wide road, has a significant amount of traffic moving on it, and that is quite a substantial impact on a development. The proposal itself has a series of other developments that have been established, not part of this application, but are intensifying a mix of activities in and around the area, and those inform the non-residential commercial nature within the precinct facing Great Eastern Highway. For the properties that adjoin it, I'm cognizant that it adjoins pretty much on two sides commercial, including the RSL hall, as well as the rear site, which has a residence and stables. From my perspective, there is a significant distinction drawn in the scheme to separate the zone out rather than just a level of discretionary use within a residential zone. Horses are different from residents, and in many councils they separate those out, recognising the impact that large animals can have on the amenity of the area, and those are very different from a traditional residential area. From my perspective, that informs my decision about the suitability of the context of this development. I'm also satisfied that the design of this proposal is very well thought out and considered in its location. It includes a significant tower, and I accept that that is within the existing provisions of height and therefore are within the framework as set in the current scheme. But it is unusual for us to see so little of the overall site being taken up with building, and I think the inclusion of a significant area surrounding it is a positive outcome for the area and creates an open space around the area that is supportive of the development that we see in front of us, and it's appropriate in its location. So I think that the proposal as submitted is suitable in the context that we have it and the provisions that are currently in the scheme. And as I've already indicated, it's a very long way off in terms of what may or may not ultimately get into the scheme itself.
Thank you. Do any other members wish to speak to the amended alternate?
Yes, I will, presiding member. The application, in my opinion, does conform with the planning framework. It's a good design reflecting consideration for nearby and adjoining properties. The uses proposed and the standard of development at 4.5 star is quite unique along that section of Great Eastern Highway. In fact, virtually from Tonkin Highway through to the city, if you take out the casino. Consideration has been given to the bulk and overlooking of adjoining property and nearby residents, many of which are commercial in nature. The properties, in fact, have characteristics and a lesser amenity that it normally applies to normal residential development. They operate certainly at normal hours, early hours in the morning. There's a lot of activity occurring in the residential and stable zones. Trainers and jockeys are getting their horses, walking them along the streets, quite often in the dark. And they also, the residential amenity is acknowledged to be not in keeping with standard residential areas. There's a lot of smells that come from the area. There's also movement of horse floats and service vehicles removing refuse, which incidentally is quite heavily policed by the City of Belmont. The statutory framework is appropriate. This development should be considered by the current scheme provisions. And whilst the Great Eastern Highway Urban Corridor Strategy does propose some differences in planning framework, that's not a certain or seriously entertained document. This development is similar in form to the Quest Hotel. It provides a long, narrow development from Great Eastern Highway in a form similar to this, with a lesser setback. Therefore, I'm satisfied that the range of conditions will ensure that the proposed high standard of development will be held to the proposal, and the scheme provisions will be complied with the range of conditions, a extensive range of conditions which the council has quite rightly thought through on the alternative recommendations. So I am supporting the proposal.
Thank you. Mayor Rossi, would you like to speak to the amended alternate?
Yes, just very briefly. Yes, while it's an outstanding building, I am concerned about the impact the potential development will have on the surrounding properties. Whether they are horses, whether they are commercial people, there will be an impact. There's no relationship with surrounding properties, and most concerning, there's no transition. It's both dramatic and impactful in the area. And I'm concerned that the horizontal screening may not be enough. So for that purpose, I won't be voting for this.
Thank you, Mayor Rossi. As mover of the alternate, I have nothing further to add. So let us put the amended alternate recommendation to a vote. All those in favour? Against? Thank you. Carried 3-1. Moving to item 4 on the agenda, Form 2 DAP applications. We have nil. Item 5, Section 31, SAT reconsiderations, none that relate to Belmont. Part D of the agenda, other business. Item 1, SAT applications and Supreme Court appeals. SAT applications for the DAP. All the DAP is listed on the website. None relate to the cities of Subiaco or Belmont. With that, I declare the meeting closed at 11:48 a.m. and thank everyone